righty. Good afternoon, ladies and gentlemen. Welcome to the June 26th special meeting of the Medford Site Plan and Architectural Commission. We will now come to order. Could we have roll call, please?
Yes. Mr. Bender.
Here.
Mr. Camiller.
Here.
Ms. Powell. Mr. Thomas.
Here.
Mr. Whitlock.
Here.
And Mr. Wing.
Here.
We have 5 present.
Alrighty, we have quorum. Item number 20 is our consent calendar. We have none. Item number 30 is approval of the minutes from the June 5th, 2026 meeting. Are there any additions or corrections to be noted? All right, hearing none, the minutes will stand as submitted. Item number 40 in today's meeting is oral requests and communications from the audience. This is an opportunity for members of the audience to address the commission on matters that are not on today's agenda. If you wish to speak, please come forward to the podium, sign in, and tell us your name and your concern. Anyone? All right, moving on. Item number 50 is public hearings. If you plan to testify, please listen carefully to the following prepared statement regarding the procedural rules that will govern such hearings. Statement will be read by Mr. David Schambach, who is the Senior Assistant City Attorney.
Thank you, Mr. Chair. I'm going to explain the rules that govern this hearing. Before the hearing begins, city staff will give a report. The report will list the criteria that govern the city's decision. After the staff report, the hearing will be open for other speakers. The applicant will speak first and may ask for rebuttal time. Following the applicant, any other interested person will be allowed to speak. Before the hearing is closed, anyone who needs more time to present evidence must ask for more time. If you ask, the hearing will be continued or the record will be kept open, and you will have at least 7 days to present additional written evidence. Any testimony, argument, or evidence you give must relate to the criteria listed in the staff report or other criteria in the comprehensive plan or land use regulations that you believe apply to the decision. If you fail to raise an issue or do not give the commission sufficient information so that the commission and any party can respond, you will not be able to appeal that issue to the Land Use Board of Appeals. If you do not raise constitutional or other issues about any proposed condition with specificity so that the commission can respond to that issue, you will not be able to bring a court action for damages.
In order to proceed through today's agenda in a timely manner, except that the commission's request, applicants giving testimony will be given 10 minutes to present their application. Individuals having comments about these applications will be given 3 or 5 minutes if representing a group or organization, and 5 minutes will be given to the applicant for rebuttal. Moving on, item 50.1 is AC-25-240 and E-26-080. Consideration of plans for the construction of a multifamily development consisting of 12 dwelling units together with an exception request to eliminate the planter strip, reduce street frontage landscaping, and to reduce sidewalk length. The subject site consists of one parcel totaling approximately 0.34 acres located between Medford Heights Lane and Florence Avenue. The address is 130 Florence Avenue. The development is within the MFR 30 zoning district. The applicant is Medford Heights 2 LLC. Agent is Mays and Associates. The planner is Stefan Roenfeld. Does any commissioner have any conflict of interest or ex parte contact to disclose regarding this application?
Mr. Chair,
Yes.
I don't have an ex parte conflict, but I was not at the May 15th meeting, and so I'm going to recuse myself from this item.
Okay,
Okay.
thank you.
Yeah.
I will also go ahead and disclose that I have some current business with a client, with a member of the development team, but that is on a separate item, and it won't affect any of my decisions here today, in addition to having been at the previous meetings and having extensive familiarity with the record. Commissioner Whitlock?
For the benefit of those who might not have been present at either of the prior two hearings, I do want to disclose again that I did do a site visit, actually a couple of site visits, to familiarize myself with the area and kind of see the layout of the property.
Thank you, Commissioner Whitlock. Commissioner Wing?
And in the same vein, I have done actually now 3 different visits.
Thank you, and I'll second that. I have actually visited the site several times and am a former resident of the surrounding neighborhood. With that, does anyone in attendance wish to question the commission as to conflicts of interest or any ex parte contacts? All right, seeing none. Could we have a staff report, please?
Yes, thank you, Mr. Chair. Good day, Commissioners. I am Kelly Aiken with your Planning Department. I'm kind of pinch hitting for Stefan today. He's sitting right there, can help me out when I mess up whatever it is I'm going to say for you today. So this is a new hearing, a renoticed public hearing for the Medford Heights development. And so the question is, why are we even here today? So on May 15th, as y'all noted, we had a public hearing. The Site Plan Architectural Commission voted to direct staff to prepare final orders for approval. And our standard method of operation is to prepare those for the next meeting to be adopted. So we reduce your oral decision to writing in those final orders. Part of the motion was to add a condition of approval requiring extension of the sidewalk south of the building to the southerly property line. And there was also part of that motion was to ask staff to prepare findings in support of that added condition. Because the findings would have been prepared and presented after the public hearing was closed, and there was no opportunity for anybody to respond to those findings on June 5th when that came back to the commission to adopt those final orders. Staff requested that the commission reopen the hearing and allow the public to respond to those additional findings. So we did send notices for this special meeting, and then the site was reposted with our public hearing signs. And for those in attendance today, this is a new hearing. For my part, I will focus on the question of the sidewalk, but anybody's able to speak to whatever issue they choose to raise today.
Mr. Chair and
Yes.
Kelly, just for clarification, this is really a continuation of the previous hearing. All of the evidence that has been presented at the prior two hearings are still part of this hearing. So it's technically not a new hearing. We reopened the record of the same hearing.
That is correct. Thank you for clarifying that, Mr. Whitlock. I also wanted to note, why did we have a special meeting? We're in the middle of holidays. It was kind of interesting. June 19th is a federal holiday. July 3rd is a federal holiday. Those are your regular scheduled meetings. So we called a special meeting in order to be able to meet the 120th day deadline, which I will talk about here in just a minute. So since we published the agenda last Thursday, we received a number of new exhibits and information. Some of those, I think, the last 1, 2, 3, 4, 5 were sent today, and so those are on the dais. We received, I think, WWXX and YY quite late this morning, so those are at your places today. As always, we start out with the approval criteria. The criteria for site plan applications are found in Land Development Code section 10.200. And there are two sets of criteria for site plans. We have criteria for commercial and industrial development and criteria for residential development. This is a residential property, so this criterion applies. And it's quite clear and objective. If it meets the design standards for multifamily development. And then if there are any exceptions that are required to accommodate the development, if those two things are approved, then the commission must approve the site plan application. That third criterion applies to cottage cluster development, and that what's before you today is not a cottage cluster. The exception approval criteria are found in Land Development Code Section 10.186. Staff did review the application and found that those are satisfied, just like the site plan criteria. The Site Plan Architectural Commission has authority in these application types. And the 120-day rule. So the 120th day is August the 12th. The applicant did extend the 120 days in order to accommodate this special meeting. So staff's recommendation is to adopt the final orders today. So if you do that, then we are able to work within the 120-day rule. So we are in East Medford, on the west side of Florence Avenue at the westerly terminus of Scott Street. The parcel is just right about 1/3 of an acre, about a 1/2 acre gross. The general land use plan map designation is urban high density residential, and the zoning is MFR 30, as you'd mentioned, Mr. Chair, and that is consistent with that UH map designation. Taking a look at a couple photos, on the top is from Florence at Scott Street looking to the west, and on the right side of the screen is from Medford Heights on the west side of the site looking northerly. Northerly, yes. The applicant's proposal is to construct 12 dwelling units in 3 different structures. There's 4 units in each of the structures. They're providing 9 parking spaces and 12 bike parking spaces as the code requires. The exception requests for you today are, there are 3. One is to eliminate a planter strip on the north end of the site, to reduce or remove street trees in front of the structure itself, and then removing the sidewalk at the south end of the site. I'll go over those in more detail. Taking a look at the site plan, the buildings are situated on the northerly end of the site, with parking on the west side of the site taking access from Medford Heights Lane. Density for the site is a minimum of 9 and a maximum of 15 units, so the 12 units that are proposed fall within that range. Parking. Parking is interesting. The state has given us some directives in residential development, and one of those is eliminating the requirement for to provide parking for smaller units. In this case, we have 1-bedroom units that are between about 600 and 650 square feet. So the code requires 0 parking for this development. They are proposing 9 vehicle spaces and then 1 bike parking space for each of the units. Landscaping, I mentioned that there's an exception request for the street trees, and I'll talk about that in just a moment. Otherwise, for the number of shrubs that are typically required, they are providing that the correct number. Taking a look at the architecture, they are 3 stories with a walkout basement on the Florence side, and from the Medford Heights side, they look like they're 2-story structures. The structures do meet the multifamily design standards that are in the code, with the exception of the eave requirement. The code does provide the commission the authority to adjust those standards. And the only request that's before you is to allow removal of the required eaves, and staff does not object to that. Taking a look at the exception requests, as I mentioned, there are 3. The primary reason for the exception request is the steep slopes on the site. The city has a whole ordinance around hillside development, and this map shows slopes on the site. The white areas are less than 15%. The teal colored area is between 15 and 35%, and those golden areas are in excess of 35% slopes, so quite steep. So there are 3 requests for exception that are before you. First is to remove the planter strip. Florence Avenue has some interesting existing facilities. On the southern end, there's actually curb and gutter, and so the southern part of Florence is considered a legacy street. A legacy street is a street that was built to a standard that was in place at the time. The street standards change over the years, and so we acknowledge that that is basically a legal non-conforming kind of a situation. And so the code allows some flexibility to design and be context sensitive. The northern portion of Florence is not a legacy street, meaning that there's no curb and gutter. So the exception to remove the planter strip on the north end of the site only applies to the north end. Since there's curb and gutter on the south side, the legacy street ordinance allows that to be removed. So our Public Works Department does not object to removing the planter strip. So then again, that's just on the north side of the building. So there will be a sidewalk on the north side of the building, just not the planter strip. The second is the street frontage landscaping. The fire code requires an aerial apparatus accommodation for the trucks to be able to fight fire in the structure when they need to. So what happens is that the street trees interfere with that function. So there's a conflict between the fire code and our land development code. So the applicant requested an exception for relief from that standard, and staff again does not object to that request. Finally, so this is kind of what happened at our last meeting. So this area shows the proposed development area and then a future development area. And the way we have applied the code in the past and consistently is where we have an area that can be developed in the future, we typically don't require improvements. In this case, and that was staff's recommendation on May 15. In this case, through the record, the applicant had said that they don't intend to develop that site. They could. There's 3 additional units that could be developed on this site, as I talked about the density. But the applicant had said that they intend to not do so, that they intended to preserve the oak tree and leave this area as open space. So the commission rightly then required the construction of the sidewalk in the area that is not to be developed in the future. So in response to that, the applicant then renewed their request for relief from constructing the sidewalk on the south end of the site. For context, it's about 74 feet, which equates to about 3 parking stalls based on our on-street parking standards. So I approximated, this is all in PowerPoint, so it's very approximate. The red line on the site plan is about 74 feet, and I just copied that and scaled it to the slope map. So you can see that the sidewalk would be in an area where there are pretty steep slopes. So that is the basis for the relief from the sidewalk on the south end of the site. The public comments, there were a number of comments that were received from the public, from the neighbors in this area. Stefan did a good job of responding and analyzing each of those in our staff report. We did receive a number of new comments that are generally within these same categories. The compatibility standard I wanted to address. As I mentioned, compatibility is a very subjective matter and cannot be applied in this to housing. Tree loss and landscaping. The question of that lovely oak tree is it's heavy on my mind personally. It is quite lovely. Staff did include a condition of approval requiring a tree protection plan. And typically what happens is that, there's usually like a construction fence or something on the site during construction to help protect the drip line for the tree, to give it the best chance possible during construction. So there is a condition of approval requiring that, and there's also a tree protection plan in the record. And finally, the proposed conditions. I have number 6 circled because when I put this revised report together, I failed to omit that. It was added by the commission at the May 15th hearing. Based on staff's recommendation to approve the exception, it should have been removed. So staff's recommendation is to remove number 6. And with that, staff did review the application and found that the approval criteria for both the exception and the site plan applications have been satisfied. And so staff's recommendation is for approval. That does conclude my report, Mr. Chair. I'm happy to take questions.
Thank you, Kelly. Any questions for staff at this point? Commissioner Wing?
I'm constructing it in my head. Go ahead. I pass for the time being.
Okay. Any others?
Mr. Chair, just briefly, if I may. Kelly, what is the staff rationale behind not requiring a sidewalk for undeveloped portions of a parcel?
Generally, and not this specifically? Or do you mean generally?
Generally. You talked about the policy.
Sure.
In fact, you made specific reference to some long-standing policy, I think.
Sure, that's correct. So we often see larger properties. It's not very common that we see a property this small proposed to develop in phases or have a future development area. So it's not uncommon at all for us to have a larger piece of property where it doesn't make a lot of sense, honestly, to require the full infrastructure improvements at that point in time, where it would make more sense when there is the nexus, if you will, for those for that requirement at a future time. So that is the reason that we act in that way.
So would it be fair to say that it's typically applied where you have a multi-phase development project?
Yes.
Thank you. Thank you, Mr. Chair.
Absolutely.
Add
Commissioner
to-
Wing?
Just to clarify, looking at the application of, the finding to the code, apparently there are no required parking things issued.
That's
Is that correct? But yet there is no street parking because of the width of this alleyway. I'm having a hard time reconciling the fact that there are going to be fewer parking places provided on site than there are actual units.
Yes, that is a directive. That is correct. Our code was amended probably 2 or 3 years ago now to reflect the state directive to, I think it was a housing affordability question.
Okay. So that is something directed by the state and that the city of Medford cannot amend on its own?
Correct.
Thank you.
Commissioner Whitlock, did you have something further?
Yes, just one additional. Kelly, I seem to recall that before the initial hearing on this, there was a vague reference made to an initial exception application which asked for only the southerly 25 feet along Florence Avenue to be exempt from the sidewalk requirement. Is that accurate? I just want to make sure my memory was not deceiving me.
I believe that's correct. The initial application included a stormwater facility along that actually straddled the property line and was partially in the right-of-way. So yes, that was the reason for that request.
And since you mentioned stormwater facility, where is the stormwater facility on this particular site?
I will defer to Mr. Burrows. I am not confident enough to speak on that.
Okay, thank you. Thank you, Mr. Chair.
Absolutely. Mr. Burrows?
Good evening, Chair, fellow Commissioners. Doug Burrows with the Public Works Department. The stormwater facilities have been moved into kind of planter areas in front of the units. So that they were relocated and removed from the southern section of the site. Could I take this opportunity to talk about the parking a little bit? So I think there was some discrepancy and an error on my part in one of the previous hearings about parking on Florence. Parking is allowed on Florence. However, there currently is a yellow curb along most of the frontage of this project, which prohibit parking on Florence. So I'm not sure why it was painted yellow. I think it's been that way for a long time. Some areas are pretty faded. Now saying that, it doesn't mean it can't be changed. It could be requested to be changed by either the developer or anyone else for that matter to the Transportation Committee, and they would take that in consideration to remove that no parking limitation so people could park along Florence. However, as you may remember, I think Kelly mentioned that no parking is allowed in front of the units because of the fire aerial access, but they could park on the southern area as if requested. So just want to make sure that was clear. So
Commissioner Thomas?
So now I'm less clear. So it's painted yellow, but there is parking, or are you
no,
saying
the
it's
street
painted-
width allows for parking.
Okay,
The design
but-
allows for it, but for some
right
reason,
now it's no parking.
yeah,
so-
right now it's no parking because of the yellow curb.
So the community would have to go to the transportation.
Yeah, someone would have to
committee,
make a request. They can do that with a form that's on the Public Works website, a citizen request form.
But currently there is no parking.
But
on
currently, because of the curb being yellow, you're not allowed to park there.
Okay.
Commissioner Whitlock?
Thank you, Mr. Chair. Is there parking across the street, basically on the easterly side of Florence Avenue?
That is entirely made up of driveways,
Okay.
yeah.
So
like
the
right next to
driveways
each other.
don't, the
Yeah,
layout of the
driveways
driveways
kinda-
don't permit any on-street parking then, is that?
They don't natively do that. I suppose someone could allow a guest to park there, but in essence, no. People should not park and block somebody's
Got it.
driveway.
Thank you.
So,
I
yeah.
thought I heard some comment about that
Yeah.
in the previous hearings as well. Thank you. And going back to the stormwater, have you seen a diagram of the proposed stormwater facilities?
Yeah, there's a drawing of it.
Yeah.
And shows the piping and all the aspects of it.
And is it completely restricted to the front of the
Yes.
buildings? Or
It is.
it doesn't go to the north at all or to the south at all?
No, it's pretty much in front of the buildings. There's an outlet pipe that goes through, I don't know how to point on here, Kelly. This point. Oh, just a mouse like normal? Oh, cool. Wow, how about that? There's an outlet pipe that weeps through the curb kind of in this area where you see my mouse there. But
So-
otherwise, all the landscape bays or whatever, the storm drain bays themselves are in front of the units.
Thank you, Mr. Burrows. Thank you,
You're
Mr. Chair.
Thank you, Commissioner Whitlock. Commissioner Wing, did you have any further questions?
No.
All right,
All right.
thank you.
Thank you, Mr. Burrows. Any other questions for staff at this time? Kelly, did you have anything further?
I did not, Mr. Chair. Thank you.
All right. All right. With that, I'm going to go ahead and open the public hearing with the applicant's agent to speak first, please. Commissioner Whitlock, did you have something you'd like to add?
I did.
Sorry, I'll make it formal.
Thank you, Mr. Chair. I did just want to let everybody know that everyone on the commission, at least who's here today and render a decision, with the exception of Mr. Camiller, of course, we are well aware of all the exhibits that have been submitted. And I just wanted to say that for those of you who have previously provided testimony, There is no need to repeat any of that. If you have something new, glad to hear it. And for those who have not been here before, obviously you can say anything that you wish with respect to the criteria. But I just want to let you know that we are well aware of all the evidence that's already there. And for the interest of time, it's not necessary to repeat any of that. We understand the neighborhood concerns. So if you have new concerns, love to hear them, but it's not necessary to repeat those that are already in the record. Thank you, Mr. Chair.
Thank you, Mr. Whitlock. Mr. Mays?
Mr. Chairman, members of the commission, staff, my name is Jim Mays. I'm representing the applicant, Medford Heights 2 LLC. And like Kelly said, and Commissioner Whitlock, at the first public hearing, we presented the architecture, the building, a lot of the site elements. My focus here will be primarily for the sidewalk condition. That's, I think, is probably one of the largest unanswered questions. You have received revised findings for both the Site Plan and Architectural Commission as well as the exception application. And I'm going to summarize pretty much some of the material from those documents. And you've also received a letter from the applicant's attorney, Mark Bartholomew, relating to some of the issues regarding the sidewalk. My discussion will be in three parts. Basically, the area of development policy first, secondly, the sidewalk exactions, and then thirdly, the exception application. As far as the development application, on the overhead is the language from the Public Works staff report. You're well aware of that from May 8th for the May 15th public hearing. And it outlines the policy, the ongoing policy that the city has had for many, many years regarding its review of land use applications and establishing a development area. We feel that the crucial part of our argument is that the sidewalk condition is contrary to that long established city policy as well as the Medford Land Development Code. Section 10.500 requires sidewalks of developments, meaning the improvement of the site. And the only improvement of the south part of the site that is taking place, it no longer contains any stormwater facilities. The only thing that is there that we are taking care of is the oak tree. And that is just a protection and maintenance responsibility as part of the site. It's not development, it's not improvement. There are no improvements there that would trigger any sidewalk improvements. And although the applicant doesn't have plans for future development, the text on the overhead shows it has a capacity for 3 more dwelling units. It's possible the applicant may do that. It may be a future owner of the property that develops that property and adds those 3 units, and at which time that sidewalk section would come into play. You know, the applicant isn't asking for any special treatment here. We're merely asking that the Site Plan Architecture Commission follow the city's existing policy that has been in place historically, and we would like to be treated as other developers to follow the established Public Works policy regarding development areas. As far as the sidewalk exaction, as I mentioned, you have the letter from Mark Bartholomew, and he outlines a lot of the discussion regarding that condition. I'm going to attempt, oh, there we go. I'll put section 10.688 on the board. You're well familiar with that, I'm sure. It appears in the staff report several times, and I've underlined that sentence that is so important that there be, when you're looking at an exaction, that there be established a rough proportionality between the burden of the exaction on the developer and the burden of the development on the public facilities and services. For an exaction to be allowed, the record must show that the impacts from the proposed development are roughly proportional to the burden placed upon the developer. So a couple of slides to sort of illustrate what we're facing here. This is a cross-section of an engineer's drawing showing at probably the maximum height of the retaining wall that would need to be established or built to hold back the hillside in front of the sidewalk about 8 feet. That would vary from 2 to 3 at some of the shallowest slopes to 8 feet, possibly more, down at the southern end of the site where it gets rather steep. And at the southern end of the site, that's kind of what it looks like. Please excuse the model. But you get that is just about, you can see the corner of the property right up at the sort of the top right corner. We're looking at probably the southern property line. You can see the curb there just to my right, and the rock outcropping that's going to need to be taken out for a retaining wall. Not only will that retaining wall need to have a footing, but it will also have a metal railing on top for liability and protection for people falling over, as well as the storm drainage facilities behind it to gather the drainage water. The applicant has done a conservative estimate and as to cost, and for that 74 feet, a conservative estimate of about $56,000. The impacts that are generated by the proposed development, that would be pedestrians walking south over this new sidewalk. I want to show you, this is Exhibit 8 from the staff, from my findings, that shows the neighborhood circulation plan, the streets in blue. And you'll see the subject site sort of just above the middle of the diagram. And you follow Florence Avenue to the south, and you see that it dead ends into Mount Echo, which is a cul-de-sac street. There is virtually no circulation to the south. Anyone leaving that site that wants to go anywhere but approximately 16 residential destinations would be either traveling north to Main Street or to the east down Scott Street. And by Scott Street, they could reach further to the south. But you can't do it by traveling down Florence or over this section of proposed sidewalk. So the burden that we're talking about here, that is the excavation into the hillside to build a retaining wall, footings, drainage system, retaining wall up to 8 feet high, and metal railing. The city's burden is to make an individualized determination about the proportionality between the burdens upon the developer, that cost, and also the impacts that the development is creating upon that would warrant those sidewalks. The city has provided no facts, no individualized determination. Although there are some generalized conclusions, there are no findings regarding that to establish that proportionality. So the applicant requests that because the sidewalk condition is contrary to decades-old city policy, it's contrary to the city's land development code, and the southwest extension fails both the essential nexus and the rough proportionality tests, that the Site Plan Architectural Commission approved the application without the sidewalk extension condition. Lastly, talking about the exception application was originally submitted that did not include the sidewalk extension. But because of the condition that was added, it was, this third element was added to that accepted application. And the reason for that was that we would have, the applicant would have the ability to review that sidewalk under a different set of criteria, that being the exception criteria. We submitted findings explaining that there are unique or unusual circumstances that do not typically apply elsewhere in the city, and that the strict application of a requirement would result in the exceptional and undue hardship on the owner. That being the hillside. May I have one more minute? Thank you, Mr. Chairman. That would be the hillside and the considerable slopes with rocky composition and the lack of a neighborhood circulation plan to the south. Your city staff has made a recommendation to the commission to approve the exception application that does not include the sidewalk, and the applicant requests that the site plan architectural commission do the same and approve the exception application. And that concludes my comments. I'd be more than happy to answer any questions the commission might have.
Great. Thank you, Mr. Mays. Commissioner Thomas?
So I just have a few, and it's good to see you again. Takes me back to my school board days when you used to come in front of us. So we're here because of effectively the special meeting because of the 74 feet of sidewalk, right?
Correct.
Okay. And would you agree that this is a very unique site?
A unique site?
Correct.
Correct.
And would you agree that the planning commission who rezoned it, it was a very contentious because of the infrastructure that was around the site? So the streets, utility access, things like that. So this was a very unique situation that we were in as a planning commission, now SPAC. Would you agree with that?
It was certainly different, but as all zone changes go, there is a review that takes place of all the public facilities.
And so that did pass. So
yes,
on a 5-4 vote, I believe. So very, very close. So after working with the community members, they had a couple concerns. One was the sidewalk, and one was making sure that utilities, I mean, they had a lot of concerns, but ones that we could actually address was the sidewalk, and then making sure that all utilities that were going across that property were going to be taken care of by the applicant.
right.
Is that going to be part of the motion that you're approving? I mean,
Yes.
because you didn't speak, at the
Yes.
end of the meeting, you had rebuttal time, and people spoke about the sidewalk, and you didn't speak about the
Yeah.
sidewalk,
I
correct?
do want to clarify that, make sure that we're accurate about that condition, but that is the intent,
Okay.
yes.
So I'm kind of in a position now where we're probably going to hear a lot of testimony about the site again. But I just want to be very clear that the applicant does not believe that they should or wants to build the sidewalk.
It's not,
Okay, and
Yeah.
does the applicant disagree with taking care of all utilities that go across that property or not? Because I don't see this and that. But I just want to make sure that you get the opportunity to speak on things so we don't have to have another special meeting if it
yeah.
doesn't go right.
The applicant has said before that any of those utilities that cross the site that will be in the way of future development that need to be moved will be moved at our cost.
Okay.
Those that are remaining but are out of the development area, they will remain as they are now.
Okay. And so my concern with that now, because I think one of the reasons why it passed at planning was that it was kind of made, the assumption was made that no additional development was going to happen on that second piece. Having said that, I've lived through living near where that is what's said, it's sold, and you just basically said that it could go to a different person, correct? That it could be sold and developed, correct?
I mean, that would be,
Absolutely. And
Way down.
you have no way of knowing that.
it's only
So-
one parcel now, so.
So I want to know where your stance is on the utilities that are on the portion that is not being developed. Because my concern is that an agreement is made to take care of utilities, it gets sold, a new developer comes in and says, that's not part of what I have to do. So I want to make sure that at least the community members that are there are going to make sure that any utilities that need to be connected will be connected or
On the
moved,
southern side.
regardless of whether it's in the area or not.
I'd have to talk with the applicant about how they might want to handle that, but
But you understand my concern, sitting up
Yeah,
here, and we're
you're-
trying to work with the community to give
Exactly.
them a feeling that, you know, we're working together to come up with a
and the
solution.
uncertainty. I mean, I would say that we would be doing the same thing then as we're doing now when that future development happened, that the issue would be raised about utilities, how are they going to be handled?
Because we're protecting the tree now, but it technically could be cut down as soon as it's sold to somebody else, correct?
Not the intent, but who knows?
Okay, all right, I just wanted clarification on those two things. Thank you.
Thank you.
Commissioner Whitlock?
Thank you, Mr. Chair, and with the indulgence of the commission, I actually have a number of questions of Mr. Mays. First of all, could you go back to the photo of you alongside the roadway, please? This is actually Exhibit LL in the record. And where are you standing, at least approximately, relative to the southerly end of the property line? How far north are you
I'm
standing?
guessing here that that's probably 15 feet away behind me. You can see, I think you can see up beyond at the top right, there are fences and a corner of fences, and that is approximately the property, the southeast corner of the property. So if you took a perpendicular line down to the right-of-way from there, that would be the south property line.
All right, and I saw basically those fence posts are probably approximately 8 to 10 feet apart from each other?
I don't remember.
Okay, anyway, you're saying around 15,
I'm
15,
just
20,
guessing.
somewhere around in there?
Yeah, 15, 20 maybe.
Was there originally an application or at least a conversation during the development committee meeting about only looking for an exception as to the southerly 25 feet?
Yes. I kind of explained how that all happened. We submitted the application, went through the land development committee meeting. We were faced with a possible recommendation from Public Works to build the sidewalk down to the southern property line. We sat down with, we submitted the application, and it did include an exception to try to relieve that last 25 feet, which was the most severe, from that sidewalk condition. We subsequently sat down with Public Works and with Planning, and we talked about the area of development and the possibility of moving our storm drainage facilities out of that southern section as an option, which we did. We moved those. Consequently, we had no development taking place in that southern 1/3 of the site, and revised our application accordingly.
Right, so the simple answer is yes, and you did it because there was an existing policy that kind of exempted that area, and you
Yep.
were not planning on providing any development because you moved the stormwater facilities from the southerly part of the parcel to the front of the building.
We would have had a hard time trying to defend that.
And is it fair to say that the outcrop that you're looking out there, again, in Exhibit LL, that's one of the reasons why you looked at not wanting to extend the sidewalk to that area?
One of the reasons, yeah, well, not only would it be difficult, but it would just dead end right at that property line, and the next property on down, I believe, is a common area piece. It's owned by the association, which, in at least our common sense, it just didn't make any sense at all.
I do understand that that little peninsula there to the south of your parcel is in fact owned by another entity, and it's really not developable except possibly with a little park space or something, I suppose.
Correct.
Yeah. Is it fair to say that the $56,000 exaction you were talking about in your comments would be somewhat less if you didn't have to deal with that huge rock outcropping. Is that correct?
I'm,
It'd have to be less, right? I mean,
I would
there's no way
assume
it
so.
couldn't
I'm
be
not an
more,
engineer,
right?
But my guess would be
It
probably.
has to be more than a guess, right? I mean, you know that that's one of the problems that was cited by the attorney is the issue related to the possible costs and not knowing how deep that rock went.
Yeah, it would be less than that figure, whether that figure is accurate or not, but.
Okay,
yeah,
fair enough. Yeah, you can't say how much, and I agree with that. So, turning to kind of the exceptions or the, I guess, adjustments, there was a letter related to the eaves that was recently received. Why are you asking that there be no eaves on the structures?
It was mainly I'm not an architect, but it was a design issue.
Got it.
That the architects felt that the architectural style of the buildings would be more appropriate without the eaves than with the eaves, and with the building materials that they're now using, the functional part of providing an overhang was sort of moot.
Right. That makes sense. I couldn't remember why we were talking about that, but since it was raised specifically by someone for the first time, I wanted to at least get your comments on that. And then addressing the sidewalk policy, you would agree that the addition of a sidewalk along the southerly 74 feet, it wouldn't in any way prohibit development of that site, right?
No, it's in the right of way.
Yeah.
Yeah.
So the fact of the matter is, we're talking about something, if we were to impose it as a commission, you could still develop that site, or if not you, a subsequent owner, and the sidewalk would have to be built at that point.
Correct.
Right, okay, very good, thank you.
Although typically sidewalks are built in conjunction with development for obvious reasons.
Well, yeah, and I will say that I disagree with Mr. Bartholomew's assessment of what the code says, but I'll talk about that later. What would happen if this commission, what would happen to the development of this commission chose to impose that sidewalk requirement? Would it be so extensive that the developer would walk away from this proposed development?
If that was imposed by
This commission?
This
And
commission?
if it was also imposed on appeal, I assume you'd probably appeal if we did impose it.
there would be that option, I think, if that was the commission's decision to, and if you took that to the end, I don't know. That's
Okay.
probably for the developer
Fair
to
enough.
ascertain whether or not that it would be an absorbable cost into the development. I just don't know.
Do you have a guesstimate as to what the total cost of the development is?
I'm going to have to call on the applicant's representative.
Well, while that person is coming down, I've seen several references to there's nowhere to walk to the south of your property. And I guess my comment is it's, not unusual for people to just want to walk in the neighborhood. There doesn't have to be, in my mind, a destination like a doctor's office or anything like that.
That's true.
Correct?
Some people just like to walk.
Yeah, I know that's one of the things I enjoy greatly as well. And I would like to hear about the total cost of the project, if I may.
This is Brent. You can introduce yourself.
Commissioners, thank you. I'm Brent Hackwell. I represent COGAP Enterprises. Thank you for giving us the time and for everyone taking the time out here to discuss this project. I know there's a lot of feelings about it. Your question directly about cost, we have not finalized the costing of this project yet. As you know, costs vary, timing varies. Depending on approvals, that will allow us the opportunity to actually get us some better numbers on what it is. I will say this, it is an investment because we are trying to take a property that is more difficult to develop and actually do something with it and help this community by building housing that we need. That's what our goal is right here, right now.
So you must have some idea, though, about the dollars that you
it's-
anticipate spending on this?
It'd be purely speculation at this point. We don't
Okay.
have any final numbers.
I
I'd
doubt
hate to
that very
speculate.
much, because you wouldn't be doing this
Oh,
if you
it-
didn't believe it was.
It's over a few $1,000,000. What that number is, I don't know what
Got
it is.
Thank you.
Yes.
Thank you. And then some more questions, if you don't mind,
Sure.
for Mr. Mays. Thank you
Oh,
very
thank
much
you.
for your comments. And again, my apologies to the commission, and thank you for your patience here. I did want to ask you to address the concerns raised in Exhibit NN by the Romitis, if I haven't mispronounced that name. They talk about, first of all, the service interruption with respect to moving those easements. I think it basically says ensure uninterrupted service, and I think that is just impossible. You can't change a connection without some interruption, but I was thinking at least minimal interruptions and reasonable or something like that. Would you be willing to accept something like that?
Certainly, and I appreciate you bringing that up, that point. It was something that I wanted to clarify also, that would be impossible to have
Of course.
uninterrupted.
And I know that really wasn't the intent. I think they're just saying they don't want to be days without
No.
their services.
I mean, we're talking, I don't know how long, an hour, 2 hours, something.
Well, and I was also thinking that some of it could fall within the responsibility of, for example, an internet provider to make some connections as well. It's hard to know if there's fiber or something like that. So there are things I know that you can't anticipate or deal with at this point. The second concern was about moving the parking lot. Do you have a reaction to that one?
I mean, the parking lot is where it is. It's functional. All of the other parking on Medford Heights Lane backs into the alley. I think that, I mean, I'm looking at it as being kind of a good neighbor situation. If someone delivery truck is making a delivery, you need to back out, you will politely ask them if they can move so you can maneuver your car. There has to be that sort of cooperation, I think.
And the fact of the matter is, you could have not provided virtually any parking spaces.
That is true.
So it does provide at least some parking relief for the neighborhood. Not
Most,
necessarily for those across from it, but, and then they also ask about a loading and delivery zone.
And correct, there is not a zone that is being provided for deliveries. And it seems to be the pattern that delivery trucks, it's a 20-foot wide alley, so there should be room pretty much for regular vehicles, for two-way traffic to get around someone. Large trucks perhaps may need to make some accommodation. I mean, there again, there may be a little bit of waiting, but I'm sure that takes place now.
Could a larger truck fit within the parking lot if there were no vehicles parked there?
Perhaps. I mean, that might be something that happens when I'm sure that there is a lot of negotiation between neighbors. I'm having a party. Do you mind if I use some of your parking tonight? That in
Thank
kind
you.
of a neighborly way.
Thank you. And finally, there was a concern raised about light glare and light escaping from the property. And
Yeah.
could you comment on that, please?
What I will say is that the architects went to great lengths, as all architects do, to make sure that all light meets the standards. The city has glare standards that will not be violated. We don't feel that there's going to be any necessity for any fear from the neighbors because of the lights.
Thank you. And Mr. Mays, again, thank you for your patience with me
Oh,
and
no,
all
I
these
appreciate
questions. I really
questions.
appreciate it. Mr. Chair and commission members, thank you for your patience.
Absolutely. Any further questions of it?
Mr. Hackwell would like to also answer one of the questions that was asked about construction?
Please.
If possible.
Thank you, I appreciate it. Commissioner Whitlock, you had asked the question about future development and, whether building that sidewalk would impose the ability of future development. And I just want to comment on that as a contractor. So part of the reason we try to avoid doing that in future developments is we don't want to damage that sidewalk. But in this particular case, this particular lot does have a slope all the way across. So whatever sidewalk we build will probably have some type of retaining wall in front of it, probably starting around 2 feet. So it'll be very difficult to get equipment in the future there for development if we have any sidewalk beyond the development portion. You've got a steep slope on the backside. It's just going to make it very difficult for any future development if we do any at this point. I just wanted to
Thank you,
point that
thank
out.
you. Mr. Chair, if I could, my only point was that it could still be developed if we put a sidewalk there. You're right. Ideally, you'd never have to put a vehicle on that sidewalk. And you're right, I think ultimately it would have to be, if you built something there, you might actually have to build a different type of retaining wall relative to any sidewalk requirement that would be imposed at that point.
I think we'd have to tear the retaining wall out we built in order to
Yeah.
drive equipment up. So we'd literally be demoing stuff we did in order to get over it, to get equipment up to do the future development. Because you've got a 2-foot retaining wall that I can't drive a excavator up or something along those lines to excavate or do anything like that. I just want to point that out.
Okay,
Thank you.
May I follow up on that?
Yes, please.
Wouldn't it be more cost efficient then to construct the entirety of a sidewalk at once rather than construct just, initially what's being proposed here and then go back up at a later time?
No, it wouldn't become more cost efficient. The reason why is because literally we would be tearing out what we already did in the future. So it doesn't make sense to actually build
Well,
it.
that's my point, is if you did it all at once, you wouldn't be having to tear out what you had already done.
No, the reason why you'd have to tear it out in order to access the site, once we build that sidewalk and that retaining wall, I have to go over that retaining wall with equipment. So I would literally build the sidewalk, build the retaining wall, and in the future, I would tear out a portion of that retaining wall just to allow equipment to get up there.
Well, excuse me, maybe you're not understanding me. What I'm saying is if you constructed the entirety of it at once, you wouldn't have to be going back there again in the future and tearing out what you had already done.
Oh, excuse me. So you're saying if we did the entire development, we did it all at once, including the extra units?
Correct.
Yes, we could do that. Right now, that's not in our immediate plans to actually do that other 3 units. But, so it doesn't make sense for us to go ahead and keep building when we're not planning on doing that. But to your point, at one time, obviously, that is the right way to go if you're intending on, at this moment, doing everything. But right now, we don't see the market to do that many units in that location.
Okay, thank you.
Thank you. Anything else?
Any further questions for the applicant and the applicant's agent?
Thank you very much.
Thank you, Mr. Hackwell.
Reserve time for Buttle.
Absolutely. At this point, are there any persons in the audience that would like to speak regarding this application? If you do wish to speak, please come forward to the podium, sign in legibly if you have not already done so. Tell us your name and address, and offer your testimony for consideration by the commission.
Good afternoon, Commission. My name is Matt Remedian. I'm speaking for myself and my wife Shannon. We're the occupants of 200 Medford Heights Lane, probably one of the most impacted properties with this development. I know that we've been asked to not address things that have been already addressed, but I had a perfectly written speech, so I'm going to try and distill it down a little bit and not repeat myself and repeat things that you've already addressed. Number one, I appreciate the concern about the utilities because it's literally every service line I have comes across that property. I do want clarification, however, on the reconnection of these lines. I know you've mentioned the Nolan Dolan laws and he only has to develop to his property, but I'd like clarification on, is he gonna take it to my property line, or am I then now responsible to get the connection from his property across Medford Heights Lane to my service? So that's one big concern I have. Second, the parking lot. That is contentious for me. It is 20 feet wide, as mentioned, and I believe, in my opinion, that this alley is not sufficient enough to provide proper backing, not only for tenants, but myself out of my own driveway. I know that I have measured several parking lots in the area, including your parking lot out front, and that alleyway is 10 feet less than the distance between the parking spaces here in your own parking lot, as well as several other public places that I've visited. And I'm concerned about that proper spacing to allow. I think everything looks good on paper, but there really has to be a practical application to somebody really evaluating, is there proper back out space and turnaround space in this alley? You've had mentioned the delivery. Somebody pulls up their U-Haul. A U-Haul will not fit in a standard parking space and not encroach on the alley. My son will be speaking in a moment. He has a photo. We had a plumber backed into our driveway, and his photo still shows him hanging about 5 feet into the alley. So service and delivery is really a conflict with this parking lot. Okay. And lastly, I had the light, exterior lighting. I really respectfully ask that that be carefully designed and shielded so that it remains within the development site and does not create glare or light trespass onto neighboring homes. There's no lighting in Medford Heights Lane right now. While you might see that as a safety problem, there's no light. So any light there is going to be light pollution for me. So I respectfully ask you to consider these items that I've put before you and appreciate your time. Have a good afternoon.
Thank you. Next speaker? Anyone?
Hi, my name's Signesia P.D. Did you need anything else?
Your name and address and your testimony, please.
Okay. And my address is 112 Medford Heights Lane. I just wanted to read my letter. I attended the public hearing that was to vote on the site plan for the condensed housing development in the historic neighborhood between Florence and Medford Heights on May 15th. Something was stated in that hearing that has been concerning me since that meeting. It is stated that Medford Heights Lane is an alley. I also found it documented, I quote, Medford Heights Lane is functioning as a street frontage, but is built as a public alley similar to MLDC, and it has the numbers. No additional improvements are required if it is to remain classified as an alley. Since the plans designate our street as an alley, it allows the new construction to move ahead without making any improvements to our street. Stretching the truth to create a loophole seems dishonest and unethical. When the historic hospital was on Medford Heights Lane, there was a secondary road coming from Ashland Street. That road does not exist anymore, and it hasn't existed for many years. Obviously, this alley designation was from the early 1900s when the hospital and previous road existed. Please don't let this incorrect designation create a dangerous situation for all of us that live on the road and all of the residents in the Hilltop condominiums. This is very concerning to me personally because I live on this street. It's my only access to my home. There are 6 houses on the street that can only access the driveway by using the road. And I noticed that on the report it said 4, but there is 6. It seems to me that Medford Heights Lane, by the city's definition on the internet, is a street with no other access to our dwellings and with our mail coming to our house from this road. We have a street sign and are on Google Maps as a street. To complicate matters, the mail and garbage services drive the wrong way on the street. Emergency services, especially fire trucks, cannot provide assistance to us by any other street. And thank you for coming there. You know that there's a hairpin turn and it's really hard. You have to really turn hard to get onto the street. I'm respectfully asking you to correct this error on the paperwork for the new project. The proposed property should not move forward before Medford Heights Lane is correctly classified in writing as a street and receiving the proper improvements to this road, especially if there are 12 to 15 new housing units and not only 9 parking spaces. The current residents must have access to their homes throughout the building on this new project and be able to continue until the project's completed.
Thank you.
Thank you.
Next.
Hi. Hi, I'm Cindy Hardcastle. I live at 211 Florence Avenue. I'm at the corner directly across from what I have always believed is an Indian petroglyph. The picture on the screen indicates all that rock that you've been discussing that's in that section. And then there's that old oak tree, and on the other side of that old oak tree is this gorgeous rock formation. For those of you who may have visited and noticed it, I call your attention to it now. It's not a collection of piled rocks or even a solid rock. It's what appears to me to be a possible ancient Indian sacred place. I've done a lot of research since, well, last 6 months, since we learned of this project, on the subject of Indians who exist in the Bear Creek area, and the Dagelmas, they were called, about 15,000 years ago, moved to this area. They were along the Rogue River, but they also did their winter living around the Bear Creek. You guys can all research this if you like, but my point is that there's something more to this property that someone hasn't even thought about yet. You've got the oak tree. I know I love that the developer is, attempting to save that oak tree. That's great. Problem is, in my mind, is while building, you say the build area is the build area 3/4 of an acre, or is the whole section, including the oak tree, 3/4? I don't know. If it's less than, if the oak tree is taking up part of the 3/4 of an acre, well, then the build site is most certainly going to kill the roots of that oak tree. And even if it's taking up a section 3/4 acre next to the oak tree, it's also going to kill the roots of that oak tree, which will kill that tree. I know that there's a huge question mark. No one has found any evidence of Indians there, but if you actually, someone could actually go back, if you haven't noticed that rock formation at the corner, as you start up that hairpin turn off of Florence Drive, stop and actually examine those rocks, that rock formation. And then it continues. It's not just there, but it's been covered by soil. Obviously, there's a lot more rock there, and there's a lot of history there. Do you know in Gold Hill they have a Dagelma site? It's a waterfall site that they have turned into a park. That city has a benefit of preserving the history of the Indians there, and on the coast, the Dagelmas, by the way, were, I have notes here, they were forced out of the Rogue Valley and the Umpqua River valleys, and they were sent to reservations in 1856. Those that survived, they were sent to the coast ranges. Thank you for your consideration.
Thank you, ma'am. Anybody else that wishes to speak? Please approach.
First of all, can I please have this projector turned on for me?
Yes.
While he is doing that, I will continue with my speech. Good morning, my name is Zane Remedy. I live at 200 Medford Heights Lane. I'm speaking today about the loading and unloading areas of the proposed apartment and the fact that driving up Medford Heights Lane, you cannot see anything at the top of the hill and as well as the size of the road. Loading and unloading areas, having just one parking lot with 9 spots, one being a handicap, there is no room for a medium or large size U-Haul to unload or load, especially on a one-way road that is 16 feet in some spots. And if there are 2 people loading or unloading at the same time on the street, it will be undrivable. There are no loading or unloading areas for the renters of the proposed apartment or their moving vehicles. My second concern is that when you are driving up Medford Heights Lane, you cannot see if someone is pulling out of the proposed parking lot. Accidents will occur, in which you should not allow parking lot to be on Medford Heights Lane for safety of pedestrians and the renters of the proposed apartment. My third concern is the width of Medford Heights Lane. The developer and the company has misinterpreted the size of the road in the plans for the build. It says the road is 24 feet wide. Most of the road is 19 feet, and in some spots 16 feet. I also have these pictures to show. Okay. Amanda can also grab these and pass them around for you. But
Is that okay? Yeah. Is that acceptable?
and in conclusion, I prompt you to make the right decision and not allow this parking lot to be on Medford Heights Lane. Thank you for your time.
Thank you.
Mr. Romiti? A young Mr. Romiti? I didn't catch your first name. My apologies. Mr. Chair, if I may?
Yes, please.
Thank you. I didn't want you to disappear. So where do the moving vehicles park that are moving into the condominiums? Basically on the westerly side of the alley or avenue or whatever it is?
I don't have a PhD in any construction or anything, so I would not be the person to ask about that. But if he would make a parking garage underneath the building to move the cars to under the building, then you can turn that area into a move-in zone.
Yeah, my question simply was trying to emphasize that moving trucks would likely park somewhere in that alleyway now if someone were moving in or out.
Yes.
No. He's talking about you're talking about the Hilltop condos? Yeah. The Hilltop condos have their own road access and do not access through Medford Heights Lane.
Thank you.
They don't park on Medford Heights Lane to move in and out.
Circular roads, it goes around.
Thank you.
We'll just pause for a second while we deal with some technical issues.
For the projector.
And young Mr. Romiti, may we keep those photos for the record?
Yes.
Thank you.
I'm sorry? Well, just so.
Staff,
part of the
I
record.
can indicate that all of the commission members have seen the photos, so I'm not sure it's necessary
Do they need to
to,
be exhibited to the public?
pardon?
I said, do they need to be exhibited to the public?
If they want to see them, they can.
If you all have seen them, I think that's sufficient. We can make sure they're in the record.
Okay.
Mr. Chair,
Yes.
can I ask a question of Kelly, of staff?
Yes.
Before we move on to the next speaker? So, just so I have clarification, so the actual infrastructure around the site is something that we are not privy to look at and make decisions about. That was made by planning months ago, correct? So in other words, we can look at the parking lot, for instance, but if somebody's saying, hey, we probably shouldn't be building this here on the site because we don't like the infrastructure of the road, which I'm not going to agree or disagree with, but that was not in our preview, is that correct?
Let me make sure that I understand what you're asking me. Are you asking if the Planning Commission's decision on facility adequacy, which is water, sewer, street, storm drain, is something that this commission can consider at this point? The answer is no. But remember, the street question is, it's a facility adequacy question as far as the overall system capacity.
Mr. Thomas and Mr. Chair, I was going to have maybe Doug Burrows comment on the alley versus road situation and what our code says about requiring improvements.
That would be good. I mean, I think, I was listening to the testimony from planning, I think the planning had all that, but I just want to make sure that when I'm listening to testimony, the things I can and can't consider, I guess is what I'm asking.
Sure, understood. So, in a group of ducks, Medford Heights Lane is a goose. It's a really kind of a unique situation. It was mapped in 1911. So it's a long existing condition. And so the condition of it kind of is what it is. So, and I will stop talking and let Mr. Burrows address. Do we want to continue with your hearing, or should we go ahead and address Mr. Thomas's question?
I think since the issue is at hand here, I think if Mr. Burrows can approach and answer, and then we will continue with further testimony from the audience. So, Mr. Burrows.
Thank you, Mr. Chair. I think what I heard was someone asking that perhaps there should be a requirement for some improvements, and there was some distinction being made between the designation of effectively that westerly access way as either a lane or a roadway, and I just thought maybe Mr. Burrows could help clarify what the code says about requiring improvements to whatever that thing is on the westerly side of the proposed development.
Good afternoon, Chair, fellow commissioners. Doug Burrows again. Excuse me. You can comment on deficient streets. If just as we're asking them to put curb and gutter on Florence because it's not improved, if Medford Heights was some other street and it was not up to standards, we could absolutely, and we would, ask for additional improvements to it. As Kelly said, it is non-conforming to anything. There's no street standard that it is conforming to. The closest one is an alley. It's built similar to an alley as far as right-of-way width, it's 20 feet. Pavement width is about in the right area, it's close to conformance. The thing that it is not conforming to for an alley is it's acting as street frontage as well, which alleys don't do. Any other scenario, there's probably more non-conformities than there is with calling it an alley. So I think that's where it best fit in the alley designation. Calling it anything else would most likely require right-of-way, inevitably perhaps from everybody, not just this developer, to actually build it to function as any other type of street. So, like I said, this was the least resistance as far as what is the least amount of nonconformity would be an alley designation. I think that's how we landed on that. But no, I think we ask for improvements on deficient streets all the time at a SPAC level. Right-of-way dedications, PUEs, all of those things. Those are typically required. And I will say this about the PUE. I think a PUE is a condition typically of approval for a project like this. However, I believe you can grant relief from that. I think that's allowed in the code, and we basically state that in our report. I don't know if the applicant has asked for relief. Often it's warranted in situations where you're developing in a very developed site. There's already pretty much everything out there, most likely, and a lot of the communication power is all overhead, and so the PUE often is not as critical in these developed areas. So I will want to mention that. I don't know if Mr. Mays wants to speak to that maybe on his rebuttal, but that was just an extra freebie for you. So is there any questions about what I just went over?
Commissioner Thomas, did you have anything further?
No, I'm more confused, but thank you.
Are you, okay? Well, I mean, I'm happy to try to
But I
clarify if
think
you can.
that does make it much more clear for me.
Okay, all right. All right, thank you.
Commissioner Whitlock, did you have, sorry, Doug,
No.
did you have anything further, Commissioner Whitlock?
No, thank you, Mr.
All
Chair.
right,
Thank you.
thank you.
Thank you, Mr. Burrows.
Thank you, Mr. Burrows. With that, if there's anybody else, ma'am, sorry, ma'am, you've already testified here today.
I'm the treasurer of a group. May I speak again as part of representing a group? I just left off a couple facts. I was going to be brief, but if that's all right, if you don't. want to
It's okay, I'll
represent my
allow
group.
it. Please come forward.
Hi, I'm Cindy Hardcastle, once again, treasurer, Medford Heights, HOA A. And I just wanted to mention to you that if you, I'm also a map maker, and if you look at a topographic map of Medford, the area in question, there is a rise, as you know. It's been talked about, you know, that slope on the hill. And the other side of the Medford Heights HOA goes down to some other neighborhood. I've always wanted to go look. I don't know where it goes. But what I do know is beyond that is Bear Creek, and it's less than a mile, maybe even less than a half mile away from the subject property. So in fact, it is very likely that Indians living along Bear Creek did go to the hillside for sacred purposes. Thank you very much.
All right. Thank you, ma'am. Yes, please.
Terry Fredericks, 104 Florence Avenue. Hello,
I'm sorry,
Commissioners.
could you repeat that last name a little more slowly for those of us who are challenged?
Fredericks, Teresa Fredericks. Thank you. Yeah. I have a couple of questions, if I can just throw these out in here. Is there any, is there anything written on the time frame that this is going to take place? How long the whole entire?
I can't comment to that,
Okay,
ma'am.
got
But the applicant may be able to include that
Okay.
as part of their rebuttal.
Okay. And regarding the,
And if
the
I
med-
may, Mr. Chair, there's actually a time limitation of, is it 2 years or 1 year to start the development?
2 years with one-year extension available.
Okay, thank you. Regarding the Medford Heights, on our address is 104 Florence. So Medford Heights Road, the alley, comes down right next to our property. It's a one-way alley. And right now, there's some dangerous driving where people decide not to go one way and they go up the one way. And I want to make sure that's going to be addressed. That's very dangerous. Because they come around the corner, and when people are going up the one way, you cannot see around that corner. Okay, and the other one is regarding the parking on Florence. I didn't understand the yellow was there for no parking, and now the yellow was faded, and now they're gonna, I don't really understand what that meant there, if that can be written up so I could understand it. Now they take away the yellow, and now there's parking in front of our house. If somebody parks in front of our house, there's already been 2 accidents. Ooh, my heart's shaking. There's already been 2 accidents where people have pulled out of their driveways and run into the cars. And that needs to be looked at because it's very dangerous. It's a very, Commissioner Whitlock, it's very dangerous that this has happened. And there's 2 of them that happened right in front of my house because one of the person's car that was run into was a guest of mine. So I'm just telling you, there is no parking on this street. Thank you for letting me.
Sir, thank you. Yes, sir.
Well, Cindy Hardcastle, I was actually going to speak for the HOA, so I guess I only get 3 minutes, and she added something. But I'm going to start with the parking issue on Florence.
Oh, sorry, sir. Will you please state your name for the record?
Oh, I'm sorry. My name is Steve Diefenbacher. I live on 205 Florence, and I am on the board of the Medford Heights Tract A HOA. So I was going to, the parking relates also to the sidewalk, but with Florence, there's hardly enough room for service trucks to park on that north side. And so I don't think that parking should be changed. That it should be yellow like it's always been. And I'm one of the ones who has to back out of their driveways. And there are cars coming very fast sometimes down from the condominiums, which leads me to the sidewalk issue. which I still want that extended because we're going to have 12 to 24 more residents in our neighborhood, and many of them may want to walk and walk their dogs, and some of those people coming down do not really pay attention to people that are walking along that street. And I think it's a safety issue, and it was mentioned before as a safety issue, and I wish that would be considered in regard to that. Also, I wanted to mention, I was the one that mentioned the eaves, and I don't think that's going to affect the design that much to require the eaves, because that's a safety feature that prevents the walls from being hit by runoff from the rain, and it can go sometimes all the way down to the foundation, and it deteriorates the building. So I don't know why the developer wants to put those in, but doesn't want to put those in. And I don't think it's going to affect the design of the building that much. And some of the schematics did show eaves on it, as far as I could understand them. And then I had a couple things about overall building design, which I know is not my purview, but the building seems to be all painted in gray. And I don't quite understand why that's an advantage, at least for the residents, because that's going to soak in sunlight, and a more reflective color would be better for the residents and also for summer cooling. And the windows are quite narrow, and I think they should be wider to allow more air circulation in the buildings. I've looked at the schematics of the units, and there really aren't that many openings unless you go out in the balcony, and then you'll get some air. And then the one other thing I was going to mention is that planter strip, which the reason I think it should be done is because it's required by the city, and couldn't it be made narrower? And the developer is arguing that the land would have to be flattened, but the developer knew that the site was going to be a problem, and it might cost a little more money to do it, but I think it's something that should be done for the benefit of the neighborhood. So I'm hoping that these things will be at least considered and maybe addressed by the commission. Thank you.
Thank you, sir. Anyone else that would like to speak? Ma'am, please approach, state your name.
Hi,
and
I'm
address, please.
Norma Hollins. I live at 200 Mount Echo Drive. And I already sent my letter in again, and I guess I'm confused why we're here. I keep thinking, okay, it was just like to cross the T's and dot the I's. But are you really voting again to approve something that you already approved? Because, yes. So I will state that, so I would like to just state again, in addition to my letter, that I feel that a sidewalk, the full length of the proposed development, is imperative for the safety of the pedestrians in that area. And I respectfully request that you deny the sidewalk exception. There's also talk about the eaves, and the one thought, I'm just going to share this, is that maybe adding the eaves was going to make it so that you could only put 2 buildings in instead of 3. And of course, here we go. I'm starting on my tangent. It would have been nice to just have a couple of houses, but now we are faced with the 12 units, and of course, parking is a concern. Anyhow, thank you again, and I really appreciate you guys taking the time to go through all of this and to go up there and look at the property.
Thank you for your time, ma'am. Is there anybody else that would like to speak on the item?
Mr. Chair,
Yes.
maybe while we're ready, please come forward, ma'am.
Yeah.
I just wanted to apologize to Ms. Frederick. She misinterpreted my smile as disregarding her concern. She was talking about vehicles backing out of their driveway and striking parked vehicles, and I was just thinking, you know, some people hit my garbage cans when I have them in the street as well. But anyway, it was more my laughter or smiling about the circumstance. I know it happens, and as you know, generally speaking, people who are driving are responsible for not hitting stationary objects in the roadway. So again, my apologies. Thank you, Mr. Chair.
Yes. I'm sorry, ma'am. Thank you. Yes, please.
My name is Louise Shirk. I reside at 108 Medford Heights Lane. I'd like to know how when whatever his name was says this is helping the community. This isn't helping at all. I mean, anyway, so regarding the revised commission report dated June 18th, page 19 says 4 single-family homes. There is an error. There are 10. I have a triplex. That's 3 single families. Prissy Garrett's is 118 Medford Heights Lane. She was not included. And another residence has 2 rentals, and that's 2 more. So my number is 10. I'm worried about the fire safety. The fire marshal addressed the TAC and the protection for the new development. What about us 10 up on Medford Heights Lane? How is he going to save us and protect us? Also on 6/25/2023, the city received $2 million from ODOT and another $1 million from American Rescue Plan Act. Funds to support and improve the safe passage of 44 schools. Sidewalks are a necessity. I request a continuance and because of new information submitted. Thank you.
Hi, my name is Sue Riches. I live at 204 Medford Heights. In the informational packet that we received, it's a lot of information to try and digest on this. I'll just try and be brief on this. The development agent's name, Jim Mays, I will refer to him as Jim. You have heard from over 100 neighbors during the hearings about these streets in the surrounding area being actively used by a number of pedestrians, dog walkers, young families, and young children. Jim writes in his exception should be granted. He states vague justification as for the sidewalk to the south. He said it would not end in a connecting sidewalk. However, the development is planning to put a sidewalk on the north side of the development. Please note that the northern area doesn't connect to anything either. Unfortunately, Florence Avenue doesn't have sidewalks, but lots of pedestrians. Jim states that in the future, Florence will likely have sidewalks to connect down to East Main. That is an assumption, and I strongly doubt that will happen with Medford's current financial situation. He further states that people who live in these apartments can easily walk to a bus route down at Crater Lake Avenue. He has even given us an estimated time to make that walk. In reality, I doubt that that will happen. We now have many summer days that are in their 90s, and to come up the hill, up Florence, up to Medford Heights, is probably not going to happen. He further states that at this time, the developer doesn't intend to develop the site at the southern part of the property. So that shouldn't have to have a sidewalk put in, $56,000. What's that when you're spending a couple of million? I'm talking about the safety of the residents. I'm so pleased he put up that picture of himself, because that picture shows exactly space to walk in, and with any space to walk in the safety of this neighborhood is critical. People walk up what's in the roadway now, the drivable space, and as pedestrians, they like to do the hairpin turn and come up on Medford Heights Lane because they consider it a physical challenge. And that's the direction they go. Whether you believe it or not, you need to come watch it. He further states that they don't intend to develop at this time. Well, many of you will recall at the zone hearing, Jim Mays made the statement the developer felt that he could meet all the criteria and wouldn't need exceptions. When we brought this up later at another hearing, we were told that that was not the place to bring it up. When the developer started asking for these exceptions, we could no longer bring them up. I want this to be a lesson for everyone. When somebody states, in this, we do not intend to develop at this time means right here, right now, this second. It doesn't mean anything in the future. Thank you for your considerations on this. I do need my property utilities moved at expense of the developer, and I don't want to pay $5,000 to go under Medford Heights to reconnect to my house. I did not create this problem, and the applicant and the developer needs to pay for it. Thank you.
Thank you, ma'am.
Mr. Chair?
Yes.
Do you mind if we take a brief recess before we get to staff and then to rebuttal? Do you mind if we do that?
Absolutely. We'll go ahead
Can we
and
take
take
10?
5-minute
Okay.
break here.
Great, thank you.
Thank you for your patience, everyone. We'll resume our meeting in just a second here.
Mr. Chair, if I may too, just to make sure the public doesn't misperceive the conversations that were going up here, we were consulting with legal counsel about some legal issues and things like that. So it did not have to do with any of the specifics of a true approval or denial or anything else. It only had to do with some legal questions. Thank you, Mr. Chair.
Thank you, Commissioner Whitlock. Do we want to wait for Kelly?
Yeah.
Okay.
Is this when you want me to do my thing? Or no, we have to have a point.
Yeah.
To ask for comments from legal before you do your statement. I think it might.
I can just say it too if you want.
It's okay. I just thought it might look like because it actually was my request.
Yeah.
So
That's fine.
it doesn't matter.
No, do that. That is just easier.
Pretty clear. So you're just jumping in.
Yeah.
And we'll do that before rebuttal.
No, after rebuttal, before closing.
Okay, gotcha.
Once everybody's done, I'll go last.
All right, we're gonna resume order. Is there anybody else in the audience that would like to speak on the item at hand? Anyone? All right, with that, ma'am, you've already testified. Is there anybody else that would like to speak? right.
Mr. Chair, I might just add that there was a request to continue this for 7 days. The statute requires a continuance if and only if it's during the first evidentiary hearing. So the request is acknowledged, but there is no statutory requirement to postpone this matter any longer. And we do have the time frame running. Thank you.
With that, could we have, Mr. Mays, do you have anything you'd like to add?
Mr. Chair, before we get to rebuttal, can we have staff run through our comments so he has the final word, please?
Absolutely, yes.
Okay. So Dave, do you want to start or do you want me to start?
Why don't you go first?
Okay, all right. So thank you, Mr. Chair. So I just wanted to mention, at the last hearing, we had heard testimony about the private easements. And apologies, I had intended to include a condition of approval and I neglected to do so. So I think we will be adding a discretionary condition of approval, ensuring that there are easements that are provided for those private utility easements that cross the subject site. I just wanted to mention that. I don't think that I had anything else from planning unless you had something. That was all for me, Mr. Chair. Thank you.
Thank you. Mr. Schaubach, did you want to give your
I
comment?
was going after Jim, if you want to go.
Oh,
No, you need to go first so he can rebut you, please.
Yeah. I think that was.
Okay. Thank you. So I am legal counsel for the commission, and so I don't have a vote in this. That's why I've been sitting up here silently. But I have been asked by some of the commissioners to provide some legal guidance for the commission on a letter we received from the applicant's attorney. That letter we received 2 days ago. It raises some Nolan and Dolan issues surrounding the sidewalk exception. And I've been asked by some of the commissioners to describe essentially the city attorney's office position on that. The city can defend the Nolan and Dolan criteria because the Public Works findings fully demonstrate the legitimate governmental interest in promoting safe and convenient non-vehicular transportation, the essential nexus between the sidewalk and that legitimate government interest. And there is rough proportionality that A, the sidewalk is related in nature, and B, the sidewalk is related in extent to the development because it contributes to the need for safe and convenient non-vehicular transport by adding a significant number of units on a small lot in a dense neighborhood, thus adding strain to the neighborhood's already burdened non-vehicular transportation network. That said, the applicants made a promise not to develop the southern part of the lot and to preserve the historic tree there, essentially rendering this as a one-phase development. If that promise is taken at face value, the two-phase approach is a legal fiction. On the other hand, the staff's use of the two-phase approach is also defensible because if the tree dies, there's nothing prohibiting the applicant from developing that part of the lot at a later time, which would render the development multi-phase development. The city staff's long-standing practice to not require the full-length sidewalks only applies to multi-phase developments. When a person, for example, when a person builds a single-family home in the city requires them to build a sidewalk across the entire frontage of the property. The city doesn't tell the owner, you only have to build a sidewalk in front of your house. Don't worry about the side yard unless you develop that later. That would lead to disconnected sidewalks and non-vehicular transportation networks throughout the city. The applicant's Nolan Dolan letter from their attorney essentially forces the city to address this multi-phase development legal fiction and asks the commission to view the project as a single-phase development. The memo asks the applicant to have both options here by deeming the development to be multi-phase for the purpose of not having to build a full-length sidewalk, but it's also making promises that it's only going to be single-phase, and that's the legal fiction we're talking about. So there's a case that the memo omitted, and it's called Hallmark Inn and Resorts versus City of Lake Oswego. In that case, the applicant developer there sought to exempt itself from contributing to the non-vehicular transportation network in its vicinity, but it had increased demand to that same network by virtue of its development, yet it had contributed less to the same network than its neighbors. And this is a similar situation here where the applicant proposes putting 12 units on one lot, more than its adjoining parcels, but it doesn't want to put a sidewalk on the southern portion of its own lot to connect to the adjacent community and allow its residents safe and convenient non-vehicular transportation. That said, the city can defend the Nolan and Dolan criteria on whether people want this sidewalk or not. The city attorney's office recommends that the focus should be on this exception criteria, not the Nolan and Dolan issues that the memo raised and I've been talking about. Our office believes that we can defend this condition constitutionally, but that the exception criteria gets to whether we should impose it as a matter of policy. With respect to the exception request, if the commission focuses on the exception criteria of the proposed requirement to build a full-length sidewalk, it allows the city to sidestep the Nolan-Dolan arguments raised by the applicant's memo. It reduces the risk of financial liability to the city by instead utilizing existing criteria and code that is objective and without risk of potential financial liability to the city. That said, there are good faith arguments on both sides to either deny or grant the exception request. There is a legal basis to deny the exception request, but the city attorney's office is supportive of staff's position in granting the exception, especially given the city's longstanding policy of only requiring sidewalk frontage to the extent of development and the applicant's promise not to develop the southern part of the lot and preserve the tree there.
Great. Thank you, Mr. Schambach. With that, if the applicant's agent would like to submit in rebuttal? Sorry, speak in rebuttal?
Thank you, Mr. Chairman. Once again, I'm Jim Mays, representing the applicant, Medford Heights 2 LLC. Thank you for the opportunity to let me provide some rebuttal time. I don't know whether I'm prepared to respond to the legal argument made by Mr. Schambach, although I do respect their feelings about being able to support the Nolan and Dolan issue. We still feel strongly that we're not expected to rectify a situation that exists in an area with poor, if non-existent circulation. I mean, the thrust of my understanding is that we are responsible and the approving authorities ought to be looking at the impacts that we are creating for the most part. Having said that, I'm going to let that issue stand. Mr. Bartholomew I'm sure will receive your notice and be able to digest it. And I appreciate the fact that you are allowing the exception to be acknowledged and recommended as approval. I do hope that that is something that the commission considers. We feel that it does make sense. So with that, I'm going to try to respond to some of the neighbors' comments. They're not in particular order, but several dealt around the improvement situation of Medford Heights Lane. It is, as Mr. Burrows explained, kind of a non-conforming situation. It is 20 feet of right-of-way. On our site, we have set the parking back 4 feet to provide 24 feet of backup space, and that is what is required by code. That's what you find in parking lots in all backing areas. So from that aspect, we've met the code. I'm not sure whether the other parking or other driveways have that same situation and maybe have a more difficult time in backing out, but we have met the code for our development. And as I said before, you know, in a narrow situation like this, it just, where there are utility vehicles that are temporary, people just have to be respectful of one another and be neighbors, and know that you maybe have to drive around someone or maybe even have to stop for a couple of minutes to get by. But that's maybe one of the benefits, I guess, to live on a small area of the city in a delightful neighborhood with a narrow street. I do want to talk about the utilities and make sure that we understand what the applicant plans on doing. There are apparently utility lines. We're not sure what and exactly and where they are. There apparently don't seem to be any easements. So during construction and pre-construction, the applicant intends, if they find any utilities that the development is going to interfere with, whether that be water, sewer, internet, gas perhaps, that those utilities will be rerouted at the applicant's expense and to connect around down to, I'm assuming, Florence Avenue, somewhere in Florence Avenue. Now, the applicant will not do that for all of those utilities because some will not be affected by this development. They're off to the south. Those utilities will remain in place unaffected. I think that the condition is, though, to provide an easement over those. But as far as the ones that will be rerouted, they won't be taken all the way back to the residents. They'll be intercepted somewhere that makes logical sense on the site, rerouted around the development and back down to the meter or the junction area down below. And again, as we talked about, the reinstallation will be held at a minimum. There will be some lag time between connections, so it won't be without interruption, but the interruptions will be held to a minimum. Is it my time?
It is.
Okie doke. I have a few more things, but they may be just repetitions of what we talked about before. So with that, I do request the Commission's approval of the exception. I also request approval of the Site Plan Architectural Commission application, but we would appreciate your positive vote. Thank you very much.
Thank you, Mr. Mays. All right, with that, I'll go ahead and close the public hearing. And do we have a motion for consideration? Commissioner Whitlock?
Thank you, Mr. Chair. I'm going to propose that we handle the exception first and then with a second motion handle the entire development project. I would move that the Commission adopt the findings as recommended by staff and adopt a final order approving the street tree and planter strip exception request partially approving the exception request for the section of sidewalk 25 feet from the southerly property line, and denying the exception request for the section of sidewalk starting 25 feet from the southerly property line and extending northerly to the southernmost improvement within the proposed development area. The partial denial of the sidewalk extension exception request is based on the following findings as to MLDC 10.186 sub 2 sub A. The Commission finds that fully granting the exception would be injurious to the area and to the health, safety, and general welfare of the public for the following reasons. And these first two paragraphs I will indicate generally follow the Nolan-Dolan findings set forth in the Public Works report. The first is, this is a pedestrian-centric neighborhood with limited sidewalk. The additional traffic, both vehicle and pedestrian, generated by this development will contribute to an increase in demand for sidewalks. Constructing sidewalk along this frontage will help mitigate the safety risks associated with pedestrians having to walk in the street due to lack of pedestrian facilities serving this development. Second, this development is providing limited parking, which will promote additional pedestrian trips from the site, thereby increasing the pedestrian impacts over what normally would be anticipated from a development of this type. On-street parking along the southern portion of the site may be utilized, as explained by Public Works, and the sidewalk will give residents of the complex and their visitors a safe place to walk to the proposed units. Additionally, the Commission accepts and adopts the statements of Laura McCormick in Exhibit GG, provided in support of extending the sidewalk to the southerly boundary of the property. That concludes my motion.
I have a motion. Do I have a second?
Second.
I have a motion and a second.
Who was the second?
Should we have Commissioner Thomas?
Thank you.
Do we have a separate roll call on each one?
Yeah, discussion
Okay.
first. Yeah,
Yeah.
yeah, separate.
All right.
Separate roll call.
Great. Thank you, Commissioner Whitlock. Any
I would like to
discussion on
kind
that?
of explain.
Please.
So that 25 feet, of course, relates to, I believe, what was the initial, at least suggestion of an exception request. I think it avoids that largest and most complicated boulder, if you will, or rock outcropping next to the roadway that would increase the costs, I believe, substantially. I think also the height of the retaining wall would be substantially less in that northerly, what is it, 49-foot strip or something like that approximately. So I think this accommodates partially some of developers' concerns, but I think it also addresses what I considered the most important thing that this commission had discretion to deal with, and that is the sidewalk, and adding at least some additional safety in that area. As I said, anybody can use it, but specifically for the occupants and visitors and effectively the traffic related to this development. I also want to add that I very seldom disagree with staff on their recommendations. And in this case, as I believe staff always does, they bend over backwards to assist developers because there is an urgent need for housing within the city of Medford. And they just do a good job of encouraging development and working with developers to find ways to accomplish things. Because of the nature of this site, it is extremely complicated, and of course, not everybody's ending up happy. The people who live there certainly don't want it to happen. But I still believe, as we expressed last time, that this commission's hands are substantially tied by restrictions that have been placed by the state legislature on this commission's ability to impose conditions that are, in any effect, discretionary. They have to be objective and specific, which is what the development criteria are. I do want to specifically comment on Mr. Bartholomew's legal submission. That's the attorney for the developer. MLDC 10.500, he says only applies to the portion of the lot that is developed. Basically, where you disturb the soil, that's the only place you're required to put in a sidewalk. The logical extension of that argument, and I think that's not what the code intended, and I'll explain why in a minute, but the logical extension of that argument is that if you don't disturb the ground next to the roadway, then if you leave a 5-foot strip, you haven't developed next to the roadway, and therefore the development area, you'd never have to put in a sidewalk if you approached it that way. What the code says is development is defined as the improvement of a parcel of land. And then development means improvement, but it refers to improvement of a parcel. Staff has interpreted this, I think, to the benefit of developers, and reasonably so, I might add, looking at the multi-phase approach, that we can wait to get that sidewalk in a subsequent proceeding for the undeveloped portion, basically. But I don't believe that's what the code says. I think the code is specific that it's an improvement on a parcel of land. Mr. Bartholomew's argument inserts the additional word improvement area of a parcel of land, and that's not what the code says. The parcel has an improvement, therefore the parcel should have sidewalks all along the edge unless it meets the multi-phase aspect, or there's an exception granted. So I believe the 25 feet exception granting is very reasonable. I do want to comment at least additionally on the Nolan-Dolan arguments. Mr. Bartholomew argues that there must be a code requirement that the exaction, in this case sidewalk extension, must be imposed to meet criteria for approval. He says there is none, and I say that MLDC 10.500 is exactly the code section that requires that under Nolan-Dolan. So anyway, I respectfully disagree with Mr. Bartholomew, as we sometimes do, oftentimes agree, but not in this particular case. So I did want to add those. You know, I probably should make a couple comments about some of the testimony. There were comments about the Indian sacred rock, and we just can't support anything that speculative. If it really is some sort of sacred rock formation, and you can get some tribal entity to agree with you, it may be a possibility, but we really can't consider that. Fire safety was raised, and that was very adequately addressed last time by the fire marshal. This development will in no way interfere with defending fires to the west of Medford Heights Lane. I appreciate the concern about the driveway, or excuse me, the backing into the alley, but the truth of the matter is property owners have the right to back into that alley. The current property owners do on the westerly side, and there's no reason why it shouldn't be allowed on the easterly side, in my opinion. I did want to talk about the eaves and the reflective color and some of those things, and I appreciate those, but those are really design elements that I am not qualified to comment on, and I think this commission should perhaps not even tamper with those. There was a request to keep the planter strips. My motion would allow the removal of those planter strips, and I think the justification was well substantiated in the staff report. Again, I respectfully disagree with those who wanted to do that. I think that concludes my comments. Thank you. Thank you, Mr. Chair, and again, members of your commission, for your patience in handling some rather complicated issues related to this particular development application.
And thank you for your thoughtful consideration of all those particular items. I agree with you wholeheartedly. Any other discussion on the item?
So just for clarification on your motion that I seconded, so I just want to make sure I'm clear on it, is that basically we're going to get 50 feet of sidewalk?
I think 49 if the 74-foot
Approximately.
estimate. Yeah, it would be 49 extending from the development location to the south, and it would omit that area with the complicating rock outcropping that I think added substantially to the cost of the sidewalk.
And I'm going to support the motion, even though I want to vote no on the whole project at this point, because I'm very concerned after speaking to Doug that we can consider the roadways, but I'm going to support the motion because I want to make sure that we've at least done that for the community that lives there.
Thank you.
I would also add that I had also considered including the entire 74 feet of sidewalk, but I think it is a reasonable concession, especially given that I mean, the sidewalk really is going to have to end at somewhere along Florence Avenue, either at the southerly boundary line, and it won't go any farther south, but this seemed like a logical breaking point to save the developer some money. And as I said, residential units are a valuable commodity in this community right now.
Thank you. All right, with that, could we have roll call on the motion, please?
Yes, Mr. Whitlock.
Yes.
Mr. Thomas.
Yes.
Mr. Wing.
Yes.
Mr. Bender.
Yes.
That's 4 yeses.
Okay, motion passes. I believe we have another item for consideration, or for a motion. Commissioner Whitlock, were you?
Thank you. Mr. Chair, I would move that the commission adopt the findings as recommended by staff and adopt the final orders for approval of AC-26-035 per the revised commission report dated June 18, 2026, including exhibits A through 1 through ZZ, and all the revised exhibits identified with a -1. I would ask that condition 6 of exhibit A1 be amended to read that the applicant should be required to submit a revised site plan showing the curb-tight sidewalk extended to a point 25 feet north of the southernmost property line. Motion includes an adjustment to the buffer yard standards in MLDC 10.790 to allow for the building wall to serve as the buffer yard wall. It includes to extend the curb-tight sidewalk to the southernmost, to a point 25 north of the southernmost property line, as identified in the exception request. And finally, it includes a requirement that the developer move and reconnect the private utilities impacted by the proposed development at the developer's expense while incurring only minimal and reasonable service interruptions. Developer shall also provide permanent easements for all private utilities crossing the entire parcel. That concludes my motion.
Thank you. I have a motion. Do I have a second?
Point of inquiry before going to the second. If I understand Parley Pro, we would need to take this amendment as a separate issue to vote upon. That is, in other words, to vote whether or not to amend the proposal before we go to the general motion.
No, this is a motion to approve the application.
Yes, but the application, does the application include the language that you just read in terms of amendment?
Which amendment? The exception that we read?
All. Okay, my understanding is of parliamentary procedure is that you approve a final, motion, a final application, whatever it is, but you're proposing that their application be amended as such, correct? Amended given the wording that you just inserted.
Well, it doesn't really amend their application, but what it does is we are ordering things different than what the application proposes.
Okay, that's what I thought.
But it doesn't amend the application. The application is what it is.
Okay, but if, what I'm saying is, I think we need to move to approve what your proposal first, and then go to approval or non-approval of the application.
No, I think it's a single motion because our order of approval is including some conditions that are not in the application. So it's imposing different requirements than what was in the application. If we approve the application as submitted, even what staff has proposed is different.
Okay, well, that's a difference from, classical standard parliamentary procedure, but I will defer on this.
I think we use more of Robert's rules, but
Well, Robert's rules come out of Parley Pro, though.
I understand, but you don't have, okay.
All right, so we have a motion.
We have a motion. Do we have a second?
Do we have a second?
Second.
Great, we have a motion and a second. Any further discussion? Commissioner Wing?
Well, I cannot, in good conscience, support this application. The change that, I'm not even going to go back to the original change of the zoning that made this possible, because I think that was based on a logic drawn from the time that the hospital was there, and therefore that must, anyway, I'm not going to go into that. But I felt that was disingenuous, and had that not happened, we would not have nearly the complications that we do. I think, I've heard arguments that say that every element, if we specifically apply every element according to what the state of Oregon has stipulated, that we are not allowed to, apply interpretation, and that every element may meet the criteria, but the overall impact of this proposal is inappropriate for the site, specifically because of the traffic way. The alleyway as it actually exists is barely adequate for existing development. And I understand how important it is that this city be building more housing. I mean, you can ask anyone who knows me, I'm a huge advocate for increasing our housing stock. So there's no question there. I'm not, some sort of a Luddite who wants this town to be, pulling up the ladder and preventing people from moving here. But in a city that is as automobile-centered as Medford is, and we know that, and we've had all these cutbacks in RVTD and the like, I think it's disingenuous to be approving anything that has fewer supplied parking spots, regardless of whether it meets the state requirement. It's disingenuous to build anything that's supplying fewer parking spots than there are actual units being built. And particularly with all the things noted, the fact that this alleyway is an alleyway, and again, this is my primary reason for revisiting this, because just to confirm that I'm not missing something along the way. And, I would be more prone to, actually quite prone to support this application if we had adequate streets supporting the housing that is there. And as I said, as they are now, it's pretty dicey whether the existing alleyway is adequate. And then to add this many units on an already inadequate transportation network, I'm sorry, I cannot in good conscience support that.
Kelly, could you put up the criteria for me, please? So Hal, I wanted to, I appreciate your concerns and your comments. As a, well, let me just say that if you look at the criteria, it requires that the Site Plan and Architectural Commission to.
I know what the criteria are. I am telling you what my position is, and if that offends anybody, if you feel that I'm acting inappropriately and you want to ask me to step down from this commission, then so be it.
No, I just want to, this is not as much for your benefit as it is for those. I don't especially like all aspects of this development either, but I do feel obligated to abide by the rules. And that is in fact what property owners are entitled to in the state of Oregon. They are entitled to have the people who are making decisions abide by the rules and restrictions that have been imposed. But I say, I respect your comments. I don't especially like this development either. If I lived in the neighborhood, I wouldn't want it there. It's too many. But it is, in my opinion, within the constraints imposed by all of the rules, and therefore I believe that we are required to approve it with any conditions that we are free to impose, and those are, as you know, fairly narrow.
Well, I think you're correct. Legally, absolutely correct. I am merely saying that I have to look sometimes at the difference between what is legal and what I can morally support.
Mr. Wing, I understand where you're coming from, but in this case, it is very clear that this is the law, and we have to follow the law.
Anything further?
So,
Commissioner Thomas?
100% agree with you. That's the way I want to vote. The reason I'm supporting the motion is I want to make sure that we get the sidewalk. I want to make sure that we get the easements for the utilities. And the only thing I would say is I think a lot of stuff happens in this state. A lot of stuff happens in this state that people just don't know. And, you know, the parking thing, as a business owner, knowing that they can build a development tomorrow and there could be no parking for my business because it's in the corridor, so there doesn't have, because there's a bus route that goes by, so there doesn't have to be parking for my customers, and we have a lot of customers that are, you know, maybe elderly. I just hope this is an example of why when your legislature says parking's bad, cars are bad, maybe you need to think those things through a little bit, because it frustrates me as somebody that cares deeply about affordable and available housing. I mean, I have a couple daughters that are extremely professional. One's a doctor, one's a pharmacist. They'll never come back to Southern Oregon. And one of the reasons is because of available housing, not affordable housing. But I think when we're doing things like there doesn't have to be parking and there doesn't have to be, that's going to cause conflicts in our community. So I support the motion. I'm going to vote in favor of the motion. I support the reason why you're not supporting it. But I hope in the future all of us really look deeply at what our legislatures are approving, because this is an example where they didn't have to have any parking and we'd still have to approve it. They could have had no parking lot at all, and it doesn't matter whether there's room on the street to park or if they have to park 3 blocks away. That's what our state has given us, and that's the law. So there's not much we can do about it.
I would add on the no parking issue, you know, the general consensus is that it becomes a market-driven decision at that point. And that if you develop without parking, you know, you place yourself at a market disadvantage. So we could argue that fact all day long, but generally I will say I'm in support of the motion as it stands. With that, any further discussion? All right, could we have roll call, please?
We need a second first.
Mr. Thomas seconded the motion.
Mr. Thomas, second.
I missed it, sorry.
Yes, sorry.
All right, Mr. Whitlock,
Yes.
Mr. Thomas,
Yes.
Mr. Wing,
Abstain.
Mr. Bender.
Yes.
We have 3 yeses and 1 abstain.
Thank you, everybody. With that, we'll move on to item number 60, which is written communications. Item 60.1, AC-23-083, which is consideration of a request for a one-year time extension for the approval of the construction of four two-story buildings totaling 32 multifamily dwelling units to be developed on two contiguous lots totaling approximately 1.81 acres, or 1.91 gross acres, located on the east side of Lozier Lane, approximately 700 feet north of Stewart Avenue. The properties are within the SFR zoning district. The applicant is SKB Hotels LLC. Agent is Savage Land Use Consulting, and the planner is Keegan Benson. Is there a staff report or anything else?
I don't have a presentation, Mr. Chair, but I will just say that they've requested the one-year extension. They're working on design.
Okay.
Thank you.
Commissioner Whitlock?
Thank you,
Is
Mr.
there a
Chair.
motion?
I would move that the commission approve the one-year time extension to June 12, 2027 for AC-23-083 per the staff report dated June 12, 2026.
Second?
Great, I have a motion and a second. Any discussion? Could we have roll call, please?
Yes, Mr. Whitlock.
Yes.
Mr. Thomas.
Yes.
Mr. Wing.
Yes.
Mr. Bender.
Yes.
And Mr. Camiller.
Yes.
We have 5 yeses.
Motion has passed. Which brings us to item number 70, which is new business. We have none. Item number 80, report from the planning department. One of the greatest hits.
All right, thank you, Mr. Chair. The only thing I wanted to mention is we do have business scheduled for your July 17th meeting. Actually, two interesting projects, both residential development. One is 500 units on the east side of town. It's on the north side of Owen Drive. So I would expect some participation at your next meeting, just so you know.
Did you say 500?
I did indeed.
Owen Drive, sure getting a lot.
And then that's all that I have for you, unless you have
With
questions.
zero
for me.
parking?
Not in that area. All right. Thank you, Mr. Chair.
Thank you, Kelly. Because my brain is scrambled. Item number 90 is messages and papers from the chair. You already know where I stand. Item number 100, propositions and remarks from the commission. Anyone have anything they'd like to add?
Mr. Chair, just briefly, again,
Please.
my thanks to the commission for your patience. I spend way too much time talking, but I also spent a lot of time reviewing and preparing and making sure that I understood everything as well as we could. I agree with Jeff Thomas, that there's a lot of stuff I didn't fully understand about the roadway and that sort of thing, but I feel like the commission did what we are legally obligated to do. And I also want to apologize to Hal if you felt my comments were disrespectful. I didn't intend that at all.
None
and
taken.
I fully understand the position that you wanted to take and could have taken if you chose to do so.
Well, I appreciate that. And to be perfectly honest, I knew that in saying that I was planning on abstaining and not going against the requirements of the office, but I wanted that to be read into the record in hopes that maybe that can be the foundation for the state to change the law. And, at the very least, my point was I felt like every single piece passed, the whole thing about the whole being greater than the sum of its parts. And it struck me that, yes, of course, everything met each of the individual criteria pieces, but that if you took them as a, what we call a gestalt, it just seemed to be going very much against the spirit of the law. And I'm just hoping that's something that will be addressed by the legislature or by, if we have any any power to change city code, but it sounds like we probably don't. But thank you, Commissioner Whitlock.
The only thing I would say is it's okay to vote no. I do it a lot, and staff looks at me like I'm crazy. It's okay to vote no. Because the only reason I didn't vote with you on this one is because I wanted to make sure those
passed.
other things, the exceptions with the sidewalk and stuff passed. Otherwise, I'd have been with you.
Yeah. If I might, Mr. Chair, just a quick comment.
Please.
So, Mr. Wing, if you do choose to vote no, a reason explaining why you choose to do so is really important.
That makes sense.
Especially on appeal.
Especially, well, yeah, and I don't want to put the city into any kind of legal hot water.
We've
That's
all
my
done it.
job.
We've all done it. It's okay. Mr. Schaumbach, did you have anything? you'd
Yeah,
like
I was
to
just
add?
going to say, I think I just want to give a shout out to Public Works staff, the Commissioner. You guys spent a lot of time on a very complex issue, and I appreciate all your efforts in it.
Did you just say public works staff and not planning staff?
I apologize. I thought I said both planning staff and Public Works, but
I could tell by the look on Stefan's face that you
I'm
omitted
sorry.
him. He
I'm
looked,
sorry,
his
guys.
jaw dropped.
He was crestfallen. All right, everybody, thank you for your time today, and with that, we will stand adjourned.
Thank you.